for Advanced Study at the University of Johannesburg. And on behalf of Faculty of Humanities and JAIAS, I welcome all of you to this important event. We will be discussing a book by Professor Kamari Clarke. Professor Clarke is a distinguished professor of transitional justice and socio-legal studies at the University of Toronto, at the Center for Criminology and the Center for Diaspora and Transnational Studies. She is also the author of The Fiction of Justice, the International Criminal Court and the Challenges of Legal Pluralism in Sub-Saharan Africa, which was published with Cambridge University Press in 2019. And Affective Justice in 2019 just follows this research. We will first start with Professor Clarke. She will introduce us into the book that perhaps many of us have not read. And after her introduction, we will start with our discussants. And we will start in this order with Dr. Evelyne Asaala, who is a lecturer of law at the University of Nairobi. Evelyne has published widely in the area of international criminal justice in Africa and transitional justice. As followed by Professor Hannibal Travis, professor of law at Florida International University. And he has also published widely on genocide, cultural survival, and human rights. He has a long list of publications and is the editor of the Assyrian Genocide, Culture, and Political Legacies, published with Routledge in 2017. And our last discussant is Tendayi Sithole, who is professor in the Department of Political Science at the University of South Africa, and currently a writing fellow at Johannesburg Institute for Advanced Study at the University of Johannesburg. He is the author of Mabucho Mora, Philosophical Anthropology in Azania, which just came out in April, if I'm not wrong, this year. First we start with Professor Clarke, 20 minutes introduction. We then go to the discussants, and after that we go back to Professor Clarke to respond before opening up to a general discussion. So Professor Clarke, please.
Okay, well, thank you, Fazil, for the introduction. And of course, thank you to JAIAS for the invitation to join you today and to discuss portions of the book, and as well to be in conversation with my colleagues. I have to also say thank you very much to the discussants, the three of them who are here today, who took the time to read Affective Justice and prepare the reflections. I don't take that lightly, and know in the midst of the semester, it's not always easy to add something else. So I'm appreciative and looking forward to our conversation. Now, one of the challenges, of course, with these book discussions is always the balance between those who have read it and those who haven't. So what I'll do just in my preliminary 20 minutes is to read an excerpt from the preface, maybe just the first 3 pages or so, and then tease out some of the general concepts from the book, what I was trying to do, what's the conceptual framework for doing it, and maybe include a few definitions, and then turn it over to our discussants. And then in my responses, I can certainly further clarify things as needed. So I'll turn to the preface. Okay, so starting from the first page, on the plane en route to Addis Ababa, Ethiopia, to attend my first African Union summit, I sat next to an American missionary about to launch a new church project in neighboring Kenya. Though excited about the newness of his contract, he was wary of the difficulties Americans encounter living in African cities. He was concerned that his way of life was different and that he would have to shift his standards and become at one with his parishioners. Though he never used language that was explicitly shocking and derogatory, it was clear that he saw his role as bringing a much needed form of humanitarian enlightenment to Africa. This was made palatable through the ways he spoke of Africa's cycles of violence and poverty. And then came the discussion of my work. After the usual niceties, he launched into a pointed interrogative. Quote, "Has the International Criminal Court convicted Kenyatta and al-Bashir yet?" End quote. I paused, first out of shock from the assumption that I, another North American, was like him and in ideological conformity with his worldview. And though the charges against President Kenyatta and Deputy President Ruto have since been dropped by the ICC's prosecutor's office, at the time I responded with resignation about not knowing how things would play out. And also with the resignation, I offered a familiar American trope that, quote, "they were innocent until proven guilty." To that, he insisted that if I wanted to talk about innocence, I should focus on the innocent African victims who needed justice. Here, the presumption was that the deceased and the survivors were innocent and the African elite needed to be stopped, that blood was on their hands and wealth in their pockets. For him, convicting sitting presidents of Kenya and Sudan would secure justice for the survivors of Africa. I couldn't resist turning to similarly troubling issues at home during this conversation. At the time, America's wars in Iraq and Afghanistan that have led to the death of thousands of innocent victims. But to my interlocutor, America's war on terror was a just war, unlike what he saw as the irrational violence in Kenya and Sudan. He spoke with passion, and his assumptions about justice presumed that those two trials were key to ending impunity in Africa. As this soon-to-be resident of Kenya, I could not help think about the kind of life that he was preparing himself for and how important the discourse of justice abroad was for him in explaining America's place, his place in improving the world's future. I also thought about what the latent sense of feel-good humanitarian discourses did that were popular among Northern missionaries, NGO workers, and journalists that I've met over my time in African countries. While on the plane that day, I began to think about the words of my intimate stranger, the words that he used, the images, the feelings associated with the words, and the way that they danced in our imagination and became entangled by other histories and consolidated our different feelings of justice. According to this notion of justice, understood as legal protection of those victimized by violence, it was not necessary to extrapolate further, at least not beyond what he had already. He and I knew what he meant, and yet so much was partial and unnecessary to spell out. The rest was expressed through sentimental expressions, tone of voice, word emphasis, facial expressions, hand motions, and bodily responses. These nonverbal cues reflected the type of affective bodily responses that accompanied the aspirational dreams of justice writ large. And through their passionate utterances, they constituted our alliances. What was not as evident was how the feelings of what justice is were produced through particular educational knowledge domains and perpetuated through various emotional regimes that contribute to how feelings are embodied as, quote, as legitimate. A similar set of justice convictions, also propelled through emotional discourses, were predominant during the course of my fieldwork in Nigeria, Ethiopia, and Kenya between 2013 and 2017, and certainly highlighted the ways that alliances were formed through sentimentally uttered discourses. In those cases, it was not the benevolent missionary, but African civil society activists whose affirmations of justice as law were rooted in much more than prosecutorial justice. While carrying out my research, my team and I traveled from place to place soliciting reactions to the ICC's indictments of African leaders, while also following ICC cases, collaborating with thought leaders on various online platforms, and serving in consultancy capacity in various research and policy contexts. What unfolded over the course of the study that, of course, led to this book was my reckoning with the complexities of international criminal law through assemblages that necessarily involved the foregrounding of embodied affects in relation to their regimes and hegemonic forms. This became evident through the collection of contradictory responses about the perceived culpability of African leaders. Now, so the introduction, this preface continues with a discussion of a contrary argument, human rights activists and their articulations of a different form of justice, and then a thought leader, an African scholar, and his conceptualization of justice. And in the introduction, part of what I do here is think about how we might think of justice otherwise, and how this notion of affective justice is deployed. So what I'll do in the short amount of time that I have from that intro, and of course that was to give you a sense of the framing of the book, is I'll say a few things about the genesis of the concept, define it, and then speak to a couple of the other concepts that are generative, I think, in the book. So in terms of the genesis, I started to write Affective Justice after the publication of my earlier book, Fictions of Justice. And at the time that Fictions was published, something new began to emerge, particular patterns and a recognition of patterns of indictments against African leaders. Certainly universal jurisdiction led to, and the exercise of universal jurisdiction by European courts led to one pattern of extraditions and adjudicatory practices in Europe. And then also the ad hoc tribunals at the time, we saw at large, or some of the work of those tribunals was wrapping up. And then the formation and establishment of the International Criminal Court, the first permanent court with jurisdiction for crimes. And of course, what was at large during this period and at the time that I started the research for affective justice was the argument that the ICC, the International Criminal Court, was racist, that it was indicting only Africans before the court. And what was important for me was that people struggled to find an analytic, a conceptualization for making sense of how we think about these questions of race, white supremacy, racism in the context of the indictment, while at the same time, the recognition that there was in fact tremendous, when we think about Kenya, post-election violence, 2002, 2007, 2008, in Sudan, in many places across the continent. And so enter the conceptualization for the book, or my attempt to think through what is at play here, was really to make sense of how we think through race and racism, how we think through justice, how we think through legality and liberal legality in this contemporary moment. And so I'll just share the screen for a moment to say something about affective justice then, and what I saw myself doing here. No, try again. Oh, for some reason it's not. Can you see that slide? What is affective justice? It's not picking.
No, it is not.
No, you can't. Okay, let me try again.
It was there for a moment and then it.
Yeah, and then disappeared. Okay, let me try it on this one and see if this works. Okay, So there it is, and it looks like it's staying. So what is affective justice, and how does it operate, and why is it useful in this context for these case studies? Well, as defined in the book, affective justice speaks to the embodied and emotional practices through which justice is often negotiated, through which it plays out, and through which people engage in the production of socially meaningful relationships. And how do we know it when we see it? One of the things that the book demonstrates is its materialization. So often it's through expressions, through representations, through discourses, narratives that often work through feeling regimes that people use in their own expressions of justice. One of the points that the chapter 1 frames is the complex assemblages through which affective justice and justice writ large, international justice, takes shape. And in that chapter 1, probably one of the key sets of conceptualizations has to do with the component parts, as I see it, for the international justice assemblage. And part of the argument here is that these legal technocratic practices that are key to thinking about the workings of affective justice. There are embodied practices that are felt, and then there are these emotional regimes that people deploy, that people are aligned with, that enable people to make the arguments that they do, and to even internally to justify what they do. And so if we were to break it down, these legal technocratic practices, central to them often is the concept of legal encapsulation, the idea that in the contemporary period, we're actually seeing the narrowing of justice through the featuring of the victim to be saved, and the use of and deployment of legal solutions, so often law with teeth. And what we see with legal encapsulation, which borrows from Susan Harding's conceptualization of narrative encapsulation, is the displacement of one narrative with the other. So what gets displaced through the law are often these domains of structural inequality, and they're often rendered silent. So what we see is the contemporary, the presentist manifestation of violence. We see legal questions that have to do with who committed the crime, under what circumstances, where, when, what are the temporal, the basis for temporal jurisdiction, as well as subject matter jurisdiction. And what we don't see are the displacements, the forms of structural injustice in the first place, the displacements around land and around other features that actually are the conditions that form the possible, including the possibility of violence. And so that's legal, the legal technocratic, that's the first of the third that I showed. The second, to break it down, are these retributive practices, which often involve forms of displacement where people reattribute meaning, a popular meaning, and create another meaning. And through the book, we see the workings of reattributive practice as a form of affective justice that plays out. And then the third being these emotional regimes, the reality that there already, always and already exist these regimes that people tap into, that people form alliances with as they try to explain the basis for justice. And of course, there are multiple chapters in the book where I talk about post-election violence in Kenya, 2007, 2008, and the conditions that led to Kenyatta's election. And the ways that Jomo Kenyatta, his father, became part of the emotional regime and the symbolic imaginary through which a kind of affective justice was invigorated that contributed to his successful election. Another visual that I think is important in thinking about the way that these emotional regimes work in international justice have to do with the figure of the victim, the figure of the perpetrator, the figure of the freedom fighter. There's also the figure of the law, that no one should be against the law or should be on top of the law or beyond the law is often the rhetoric. And these figures, and there are many, many figures, and in our own US and Canadian context, we have figures around Trumpism. There are certainly figures making America great again. What does that point to? What is the basis for referentiality? And so conceptually, the book attempts to think about these emotional regimes alongside these other regimes, the technocratic practices, the embodied practices that are felt, in order to make an argument for explaining how international justice in the contemporary period works. Now, one of the reasons that this question is important, of course, in this work is that here we have often it's the sovereign state, it's sovereignty that forms the basis for state power and its ability to exercise jurisdiction in law. And in the absence of a police force, in the absence of the kind of sovereign potentialities, how is it that something like an ICC or these forms of international justice gain their power? And this is part of the problematic at play. It's a problematic that many speak of, but often we don't turn to the regimes, the emotional regimes, the affective domain, the work of the making of the victim, quote unquote, not often those victimized by violence, which is in a particular context, but the figure of the victim, which in itself gains potential power, significant power in the work of international justice. The other reason that the affect and affective justice is important in the argument has to do with the globalized idea of race and racism, and what analytics are useful for thinking about racialization and white supremacy in this context. Is the court simply a racist mechanism that is only indicting Africans, or do we need to think differently about the conditions of possibility? And yes, of course, that's the argument in the text. And part of it is to clarify that race isn't simply a discursive concept that's brought into being through speech or through preferential treatment or through preferential choices. That in fact, racism and the operationalization of racism and the implementation of white supremacy is a political, juridical mode. And in many ways, following from some of Denise Ferreira de Silva's work, who looks at the role of racial consciousness as an important component of the perpetuation of race and patternings of race, as well as particular modes of production that produces subjects in particular ways. So much of what I'm arguing is that these other dimensions are equally critical that involve affective justice, the ways that the technocratic work, the ways that these regimes play out, the ways that bodily encryptions and embodied practices play out, that this is part of the perpetuation of international justice at large. And so to wrap up my preliminary comments, the book clearly is concerned with the problem of liberal legality and liberal subjectivity that has emerged on the world stage in this 21st century. It's concerned with how we make sense of biopolitical formations through which legality functions. And it's also concerned with the detextualization and the depoliticization of categories of the victim and the perpetrator, that often law flattens them into categories where victims become jurified. This is a concept that Sarah Nowin and Sarah Kendall so usefully articulated in one of their articles. And what I do in affective justice is really to show how these forms of depoliticization of these categories reflect actually a presumptively pre-political life that often aspires toward modes of social relationships that that embody hopes for a future society on one side, but also warns against threats to it. And these pre-political lives, what we see is that they're not real. The pre-political is actually a fiction. And it in many ways forces us or pushes us to think about the problematic around which violence is managed, including on the African continent, and pushes us to ask what kind of life matters for these juridical institutions like the ICC, what type of violence is managed and what type of violence is outside of its jurisdiction, and why are those forms of violence outside of the court's jurisdiction, violence that may be part of the longue durée of structural inequality, of displacement, of land inequality. And so part of what the book argues is that what we see is how structures of liberal legality actually produce the forms of racialization that are at play. We see this in a number of domains, from the nature of the crimes, so the political crimes, genocide, war crimes, crimes against humanity, crimes of aggression that are often referred to as core crimes in international criminal law talk, become revered as the most important crimes for humanity, when in fact what we see in the second half of the book is the kind of Pan-Africanist pushback that insists, even though the ability for the court to implement its terms, that is the African court with criminal jurisdiction, to come to life, to be in force, there are limits to that because it isn't in force. And in fact, no African country has ratified the treaty, the Malabo Protocol, that would put in place an African criminal court. But what we see are these aspirational components of an African court that moves us from the political crimes of the International Criminal Court, that pushes us to see other crimes like as enabling crimes, so toxic dumping, drug trafficking, mercenarism, a range of crimes that then are rearticulated as key and central to the African continent. They also speak to the temporal limitations of international justice, the ways that rules of non-retroactivity play out, and the limits to justice when retroactivity is a central component of the ways that justice is imagined for international courts. Some of what the book looks at is the problem of temporality, where indictments and culpability are understood in the short period and not in that longer durée. And so much of the text also speaks to the pushback against some of the formulations of liberal legality, and the call to think differently about justice using a new analytic, a new set of conceptualizations through which we can think through what justice might be. So I'll end on that note. There's so much more to say, but I'm looking forward to hearing my colleagues and their comments. Thank you.
Thank you so much. For those of you who joined us later, I just wanted to remind everybody that we are now going to start with our three discussants, and afterwards you can either type your question here so I can read it, or just join and ask your question personally. So we are now going to start with Evelyne. Do you hear me? Evelyne, are you there?
Looks like we lost her, Fazil. Maybe we turn to the next person.
Can just wait a few seconds if she comes back. Probably she had a kind of issue, technical issue. Evelyne, you hear me?
Yes, sorry, my internet is a bit
Yeah. Please go ahead.
Okay, thank you very much. So I will be sharing my screen. Thank you very much, Fazil. I will begin by commending Professor Kamari Clarke for her exemplary work. This is the first time I'm interacting with the literature on anthropological discussions of international criminal justice. And I find the reading quite informative and captivating at the same time. And so I just want to comment her for,
Evelyne, it's interrupting on your side. Is it possible for you to turn off your video probably, and let's see if the connection gets better?
So I just want to post my presentation. Okay, can you hear me now?
Yes, yes, yeah, yes, yes.
The screen? Okay. As I had said, I commend Professor Kamari Clarke, and
Unfortunately, the connection is not good, Evelyne. Evelyne, do you hear me? This is what happens sometimes.
okay, so Kamari begins by laying down the theoretical framework, which she has ably explained, discussing what is affective justice, the different stages, and the key components of this particular theory, and which I will not comment. So she's the expert. So I will only engage her works insofar as her discussions on how this theoretical framework then interacts with international criminal justice. And she begins by making the argument, which she has already highlighted, that international criminal justice is an assemblage of different components. And she argues that one of these forms is legal technocratic formations, which underscores the victim versus the perpetrator narrative. And through this, she brings out the limitations of international criminal justice, and one of these is the judicialization of justice. And where she equates, she argues that justice in international criminal law has been equated to judicial adjudication, in the sense that whenever there is a victim of international crimes and they're crying out for justice, then what comes to mind with regard to other forms of accountability. Now, I agree with her insofar as this argument is concerned, and I would like to emphasize the fact that, I'm one of the proponents of a broad mechanism, broad concept that the ICC cannot dispense all forms of justice. And therefore, it is important that the ICC focuses on certain aspects of justice while leaving other mechanisms also to dispense other forms of mechanisms. These mechanisms might be at the international level. They might also be at the regional level as well as national level. And so by doing this, we only guarantee effective functioning of the ICC, rather than opening up a broad way of looking at the various forms of justice that it should deal with. Then she takes her discussion further and argues that the rule of law has also narrowed the concept of victims, and therefore there is limited space in terms of defining victims versus perpetrator. And she relates to the Kenyan scenario where there was contested and divergent natures of victims in the Kenyan context, insofar as the temporal or time is concerned, structural victims, political victims, as well as economic, and the potential that some of the victims of these violations are left out of the ICC equation. And this critique on victims is also closely related to what she considers as the failure of international criminal justice to take into the political and historic violence. And while these criticisms are valid, I want to believe that the ICC focus on a certain forms of justice can only be made effective and practical if it narrows down the concept of victim rather than focusing on every kind of victimology in terms of time, structure, political and economic violations.
Evelyne, do you hear me? Because it's interrupting constantly on our side. I don't know, on my side at least. Yeah, I think she has just network issues and she's trying to, try again, come back in again.
So Fazil, how about if we move to the next one, and then maybe her internet will get better, or she could relocate. And
Yeah. Evelyne, you hear me, right? Okay, we just start with you, Hannibal, and yeah, go back to her later on. I will chat with her here. Please.
Okay, thank you to JIAS, Professor Moradi, and Professor Clarke for having me as a commenter today. I enjoyed reading the book. I generally agree with its conclusions and analytical framework. I had some thoughts I wanted to share, based upon my research and reflections. The first one is sort of about the overall thesis and the concept of justice in general, affective justice. It raises two questions: what is affect and what is justice? And is all justice a relic of affect, or an expression of emotion? A combination of pity and anger, resolve, this notion of impunity, which is at sort of the heart of the ICC's discourse, has within it punishment, and punishment has this emotional valence of retribution or outrage. Then on the other hand, what is the contrary of affect? Well, it's I think Professor Clarke mentions it's the liberal idea of legality, the disinterested objective voice. And in philosophy, that is sometimes called the logical or reason. And logos in logic is sort of a gathering of things into one. So you put a word on them, a category. And a lot of the debate within international law is, oh, you put something in the wrong category. This is not a genocide. This is a genocide. This is not torture. This is torture. And millions of pages are produced about these words and categories. And I think the book raises the interesting question, the provocative question of, is this really what we should be talking about? Like whether the right word has been used, whether the right concepts are in play, and whether this is all sort of assuming an objective subject which does not exist, or in a disinterested subject which does not exist, and that all law is political and affective in that regard, which I tend to agree with. It's similar to legal realism or critical legal studies or critical race theory, perhaps. And then many of the debates within the book, when I think about it from that standpoint, they are also logical debates, and they're not merely affective, or maybe they're both affective and rational, in the sense that many of the debates and statements in the book that are used as examples of affective justice, some of them appeal to the sovereign equality of states, which is a concept and a doctrine, a principle, and not simply, I guess we could say, an affect or an emotion. I think the book lays out well that there are good arguments on both sides of the immunity of sitting heads of state to international procedures or extradition or courts that are not their own, sometimes courts that are their own. The United States, for example, you sue the president many times, or the national security establishment, and it's dismissed on grounds of sovereign immunity, active state, state secret, all these doctrines of basically the executive branch is not subject to the laws that other people are subject to. And when people sue in the United States, foreign leaders for genocide, torture, and so forth, their claims are often dismissed on the grounds of sovereign immunity and the absolute discretion of the US executive branch to either grant or withhold recognition to other states and recognize their immunity or not. And that, I think, is part of perhaps a conceptual or a rational principle that I wonder, is that affective justice or rational justice, in the sense that this sovereignty, this sovereign equality is a principle or is well grounded in precedent and theory. Another principle that a lot of this appeals to, a lot of these debates that I read about in the book are the principle of universality. For example, at the Nuremberg Tribunal, it was said, we don't propose to recognize any crimes or punish the Germans for anything that we will also not be subject to. These are all universal principles. Everybody will be subject to them. But of course, that's not what happened. The judges, the countries that convened Nuremberg, they did not make their leaders amenable to international courts for the next 50, 60, 70 years. In the United States, we had a debate about the Genocide Convention and would it apply to us? And people in the Senate went to great lengths to say, no, it will not apply to us. Racial discrimination, segregation, treatment of Native Americans, either it's not a part of it, or we'll write a reservation, understanding, and declaration to make sure that it's excluded a priori from international cognizance and punishment of U.S. officials. This was sometimes called the sovereignty package of U.S. legislation in the implementation of the Genocide Convention, that it would not affect U.S. sovereignty, it will be about other people. And one aspect of that says, nothing in the Genocide Convention will create any substantive rights in the United States court, except for the prosecution of people by the Department of Justice, no matter where they're from, because it's primarily about us projecting genocide norms to other countries, not applying them to ourselves. So it's sort of the core of, the United States at the apex of the international system is this idea of this is not going to intrude upon our sovereignty. So where is the principle of universality? Many people ask in genocide studies and so forth. And lastly, I just wanted to talk about the future a little bit. I thought about the conference we had at FIU a few years ago about the African Court of Justice and Human Rights in its criminal chamber, its criminal jurisdiction, and how contemporary conflicts or recent conflicts might have been handled by it. I think about South Sudan, Ethiopia, even Sudan's sort of coup and protest movement related violence in recent years. And of course, Mozambique, all the destruction of Mozambique in recent years is what came to mind. And I think about how some of these conflicts are often mentioned along with perhaps Yemen and Syria as being ignored by international justice in favor of other conflicts. And it's somewhat surprising to me when I read the book. I mean, I remember these discussions faintly, but some of the leaders of what is sometimes called the Pan-Africanist pushback to international criminal law are from Rwanda, South Africa, and the Gambia, which are three countries, interestingly, that, in my opinion, have sort of invoked or taken advantage of unique international procedures that expand the scope of international tribunals and institutions. In the case of Rwanda, it had one of these two unique ad hoc tribunals that nobody else had in the 60 to 70 years after the Genocide Convention and the Geneva Conventions were enacted. Angola didn't have access to it. Biafra, many other places, Iraq did not have access to a ad hoc tribunal of that kind. South Africa had a convention expressly, sort of drafted, and all these UN procedures expressly drafted to, eradicate the crime of apartheid. But other countries, didn't have a special treaty necessarily for their unique problem or history. And the Gambia, invoked the International Court of Justice in what many people say is kind of an unusual or almost unprecedented way in the case of Myanmar. But yet they're leading in the book the Pan-Africanist pushback to international criminal justice in an ICC and so forth, which I thought was kind of ironic. You would expect, I think you hear more about Libya when Gaddafi was still in power, or Sudan leading the pushback because they are being unfairly targeted. And I think the book makes a good case for Libya being a poor use of the ICC and perhaps disproportionate and counterproductive in some ways. And we see the effects in the Sahel and the surrounding countries being terrible in the ensuing decade. And then I think about, lastly, Ukraine, and how Ukraine is now the subject of the largest investigation in the history of the International Criminal Court, which is a little bit odd because it's not the site of the largest death toll, under the jurisdiction of the International Criminal Court, not the largest crimes, not the largest humanitarian crisis in the world. That's arguably Yemen. I think when I also think about Kenya, which is maybe where I'll end this, Kenya has all these reports in recent years about the UK torture and extermination of people in the colonial era, and it's a priori excluded from the ICC or any proceeding by temporal jurisdiction, by a variety of doctrines. And of course, once again, the principle of universality is questionable or thrown out the window in that case. And the UK is sort of leading this charge for the Ukraine being subject to Russia being subject to international criminal justice for Ukraine. And yet, where is the international criminal justice for victims in Kenya? Not to mention other places where the UK was active in Africa and other parts of the world. So I commend Professor Clarke for the book. I found it to be fascinating reading. I learned a lot from it, and I look forward to the rest of the comments today. Fazil, I think you're muted again.
Thank you, Hannibal. Evelyne, can we try again and see if the connection works?
Yes, we can try again. I'm very sorry for that. So I think I will continue from where I left. So I believe I was shut down when talking about shaping public through sentimental narratives. Yeah, so the book explains how leaders and stakeholders in international criminal justice tap into prevailing emotional regimes and deploy sentiments that become institutionalized within international criminal justice. And Professor Kamari uses Uhuru and Ruto case studies just to demonstrate how they tapped into the historical emotional regimes in Kenya and how this influenced their rising to power as president and vice president, respectively. And at this point, I pose, a question or a comment, and just, ask, how do we assess the effectiveness of using emotional regimes by relying on political speeches in undivided public emotion? And this is because Kenya is really a divided emotion when we talk about, the emotional regime that is currently at place. And so you find there's one divide of public emotion that contradicts with another divide. And this also reflects on how they look at their history. So when you ask one side of the divide how they perceive the Kenyan historical emotions, they have their own biased way of looking at it as opposed to the other. And when we look at these different sides, it makes a case that the book fails to appreciate the different nuances of emotional regimes that prevail in the context of its case study. Because we cannot say that emotional regimes, can be synchronous. It's not a one-size-fits-all. We have to, or rather, the book should acknowledge the fact that we have different nuances within our current and historical emotional regimes, and therefore, the fact that it might look like our leaders are tapping into historical emotions, it's only but one-sided version that could be biased from what might exist on the contrary side. And again, there is the perception that our political leaders are cunning in nature. What they say is not what they actually mean. And somewhere in the book, the author acknowledges this from the Nigerian perspective by relating to the president of Nigeria, Jonathan Clarke. What he said in the public in that context, differing with what he actually implemented. And this is mainly based because on the inadequacies of these political speeches. Essentially, political speeches in most cases are written by experts, and the politician gets to engage them at that point of reading them. And therefore, there is a disconnect between what the speech is saying and what actually the politician ascribes to, and the two could be totally different. And therefore, in as much as we want to use political speeches to demonstrate how leaders lie or tap into historical emotions, in itself has its sufficiencies and insufficiencies. And it's important that the book also acknowledges the two-sided ways in which this can lead to different conclusions. And so the book further talks about the re-narrating culpability through reattribution that has already been discussed or rather briefly mentioned in the introduction. And this is basically where, there is a narrative where nationalists, and again, the author uses this, the case study of Kenya. Uhuru and Ruto demonstrated as the nationalists using a certain sentimental articulations against the growing legal encapsulation trend within international criminal justice. And when I get at this point, I pose a question as to whether this is the full story or the partial story. And elsewhere, I have talked about the role of the International Criminal Court in vitiating democracy in Africa. And this can be seen as in two different ways. For instance, if the ICC were to indict a sitting head of state, then this head of state will try all that is within their capability to ensure that they compromise democratic transitions and that they stay in power so that they have a position from which they can protect their interests. And in the second way, where a senior government official has been indicted by the ICC, even though they are not head of state, they have access to power. This person has the capability to compromise the democratic situation so that any transition will make sure that they access this power, and all in order to protect their interests within the context of prosecutions in the international criminal justice. And so these are aspects that I expected to see, emerge or discussed in the book, just to show or rather demonstrate to the reader the different ways in which nationalist narrative sometimes may be true and sometimes may not be the full truth about a situation. And in the case of Kenya, for instance, questions on validity of presidential elections have arisen, and there was a presidential election in which these elections were contested, which the book is totally silent on. And even though the final decision of the court does not nullify the election, several parts of the constitution, of the judgment, we find the judges acknowledging irregularities in the elections of 2013, which the book simply says were free and fair and generally acceptable. So I feel there is need for the book to acknowledge different narratives and not just have a one way of perceiving their case study, which denies the reader the ability to appreciate the other side of the story and how it can fit in within the context of re-narrating culpability through re-attribution. And the author also goes further to allude to challenges in attributing individual guilt of collective crimes. And this is where she argues that the principles that individuals must be held accountable for their crimes and not for those committed by other people. And in particular, she narrows down to Article 28 of the Rome Statute on superior or command responsibility. She discusses this article within the context of Ruto and Uhuru cases. But I find certain inefficiencies or insufficiencies within the discussion in two ways. And first is the fact that from a legal perspective, I felt the book lacked some level of analysis on the book lacked some level of analysis on Article 25 of the Rome Statute. Article 25 talks about individual criminal responsibility. So I expected to see a discussion on how the principles laid down on individual criminal responsibility embody the idea of an individual punishment for crimes committed by others. Yeah, just to justify the argument and not necessarily just make an argument without, explaining the legal context. Then also, there is need for the book to briefly analyze, the elements of the crime, the actors reas and the mens rea, as they relate to superior responsibility, taking into account the modes of responsibility listed under the Rome Statute, Article 25, before making the conclusion that now, these modes of responsibility allow or permit the nature collective responsibility as it has been argued within the context of Article 25. And on page 161, the book makes an interesting observation, which I partially agree with, that there are certain complex scenarios and where we seek to protect the interests of the people involved in these kinds of attacks and reprisals. It is not proper to resort to international criminal accountability mechanism, or rather this scenario cannot be totally resolved by resorting to international criminal justice mechanism. And I ask myself, if we are not resorting to international criminal mechanism, does it mean therefore that we are letting free or we are letting go of the people who took the biggest role in these crimes? And therefore, from my perspective, I believe that international criminal accountability is key. Perhaps what can happen is that we add or advocate for additional measures towards comprehensive forms of justice, appreciating that these complex kind of scenarios may not entirely be resolved by international criminal justice, but then we find out what the weaknesses are, or what is it that is not covered, and advocate for the mechanisms that we believe can fully cover the gaps that might be left out by international criminal justice, and not to rule out international criminal justice. And so, concerning the limits of the ICC individual culpability versus the long history of victimhood in Kenya, I think this has already been related to earlier. I hope I may have been hard on this when I spoke about the need to acknowledge the jurisdictional limitations of the ICC, and implementation, and the fact that the ICC cannot mete out all forms of justice, and therefore we just need to focus the ICC on what it can do best, and allow the growth or emergence of other mechanisms to take care of the gaps of the ICC in order to guarantee effectiveness within international criminal justice. And so my personal take is that the ICC personally does not exist to prosecute perpetrators on behalf of states. It is the state's primary role as a sovereign state to make sure that it prosecutes persons who commit international crimes. And the fact that the ICC exists, for me, it exists to encourage and to trigger the states to conduct or carry out their sovereign duties, which is to prosecute and protect its citizens from international crimes. And so in as much as we want to criticize the ICC and fault it, we are forgetting that actually the burden is not for the ICC, the burden is for the nation state, which has the primary responsibility to prosecute persons committing international crimes. And therefore, on emotional regimes within the African Union, I agree with the author that the Malabo Court is a beacon of hope for the future and furthering accountability within the framework of international criminal justice. And so, I mean,
1 minute, Evelyne.
So, okay, thank you.
Well, you have 1 minute.
Thanks, I think I'm done.
Okay, thank you so much. Thank you so much. We go directly to Tendayi. And please, if you have questions, type them, or just feel free to ask them yourself after Kamari's response to the discussant's questions. Tendayi, please.
Thank you, Professor Moradi, and thanks, Dr. Asaala, Professor Travis, and also Madam Miller, who made this gathering possible at this virtual platform. I must remark from the beginning that mine are marginal notes, and they're marginal notes insofar as I want to invite us to think about other possibilities. So I want to break from the limit, and my take is a sort of a different one, but I'm not in any kind of agreement or disagreement, but you will follow me through this preparatory remarks that I do have. Professor Kamari Clarke, thank you for taking this audacious task to write this challenging book, and in terms of its breadth, in terms of even the cases that have been taken. It's a work that I will say that it's a corpus opus which is titled Affective Justice, the International Criminal Court, and the Pan-African Pushback, which offers a meditative practice that refuses to be in the chokehold of the settler colonial grip. Of course, this is a concept that you'll not find in a book, but if you think about the concept of the longue durée, the settler colonial grip is what we must grapple with. And I must say that the book in itself, it is a book that folds other books, because if one can zoom in each and every chapter of this beautifully formulated two parts, one can see other books coming. And I'm glad that this is the further installation of what Professor Clarke has worked on from the beginning. And I hope that the book will form the part of the longer investigation. By locating affective justice as a conceptual spine of the book, and this as a critical apparatus, I would like us to think about the concept of justice to be the concept of interrogation. And this interrogation, it should go back to the institution that the book is grappling with, the International Criminal Court. And of course, what the African Union is trying to do in terms of having its African variant. I want to argue that in this settler colonial chokehold, we have to do this interrogation by problematizing the concept of justice outside the epistemic and legal apparatus that hides itself under the logos of international law, and also its attaches that you find in other epistemologies, which blind us to the fact that the legal apparatus has been a site that demands to be investigated for its criminal activities. I want to repeat, the legal apparatus that exists in terms of its epistemological formulations has to be investigated for its criminal activities, because if we are saying that we are dealing with the question of the Pan-African pushback, and by the Pan-African pushback, please, I must highlight from the incipit that this Pan-African variant is not the one of the African Union, which is neo-colonial in its inscription and expression. But it is the one that is decolonial in form and expression. And back to locating the concept of justice vis-a-vis the ICC, we have to rescue the concept international, as we know that under its settler colonial logos, international is only the Euro-North American centric formation. And as you've highlighted the beautiful book by Professor Denise Ferreira da Silva, The Global Idea of Race. So we have to think differently and refuse to be in this settler colonial chokehold that disguises itself as benevolent, that disguises itself as neutral, that disguises itself as trans-historical, that disguises itself as the norm, to really challenge it. And we must put it on the table that the concept international, it's a hypocritical formation insofar as it is expressed from the logos of the settler colonial inscription that is Euro-North American centric information. And of course, the second concept in relation to the ICC, criminal. We know that under the auspices of this court that George W. Bush and Tony Blair are not criminals in relation to this institution itself. And I'm saying this because of I want you, Professor Clarke, as you further investigate, because I like the way you did the book, that it's a launching pad. It's a continued poem, right? I will be happy if the concept criminal, which is the second formulation of this apparatus called ICC, that vis-a-vis Tony Blair and George Bush, and of course not reducible to them, right? And without being caught into the semantics or the debates that are happening of who gets prosecuted, who doesn't, what the sovereign state does, that we need to rethink about the concept criminal insofar as it is that which it is discharged or dispatched from this settler colonial grip that comes to say we are having criminals, like these racial markings that are being done, that Tony Blair and Bush are not criminals, right? And then others are criminals, and then they might be, they should be indicted to appear to the court. And lastly, in terms of this formation, the court, of course, we see the court as a neutral site where disputes can be resolved, matters can be brought into being. This court, who is the judge in this court? And who is a prosecutor? And also, lastly, who is the accused? So, as we know, we can say, oh, obviously, let's study how the ICC is formulated. But no, I'm asking a different question. In terms of these racial markings, right? That why the actual criminals are not brought before this court, but it is without making an excuse for those who must answer for the crimes that they have committed. So this breaking down of ICC is something that I would like you to think about, and also anchor the concept of the Pan-African pushback, which I think throughout the book, there was where it was left unattended. And I think this concept is the spine of the book in order for us to understand affective justice. You will agree with me, Professor Clarke, that two concepts, and I think Professor Travis touched this as well in his remarks, and I want to take something out of that, and having to think about the concept of affect, how it has been used and misused and abused in the post-modern literature, right? That it is just affect or the structure of feeling, right? And it has been depoliticized, right? So I would like you to think about having to rescue this concept if you are going to punctuate your arguments from the Pan-African pushback, that you must do a pushback against those who are bastardizing and depoliticizing the concept of affect as a structure of feeling, right? And linked to that, the concept of justice itself, because we know that in this settler colonial modern world, which is Euro-modern, of course, what we are having is that the concept of justice is nothing but just us. It means just us. And when I'm saying just us only belongs to those who are in the Euro-North American centric. And I'm not saying because of, like, we know that within each formation, there are those who are written outside. And I want to qualify this by inviting you, Professor Clarke, and forcing you to agree with me that, but humbly so, that we have the serious problem of ICC and its other. ICC and its other. And that is why I used the concept settler colonial deliberately. And of course, I'm not reducing it to the studies that are being done, but in a sense of its conceptual fidelity, that we have the violent encounter, right, of those who do not belong to the realm of the international, those who don't belong to the prosecutorial power, but those who are prosecuted, they are at the receiving end of being prosecuted by virtue of being criminalized and pathologized, by being racially marked. And again, if we go back to Ferreira Denise da Silva, her concept of globality, right? Her concept of globality and the manner in which she troubles the givenness of the absolute concepts of truth, objectivity, neutrality. And as you know, that insofar as justice is concerned, we are told that those who are adjudicating and administering justice, they are just objective, they have no socio or geographic experiences, they have no biases, and should you criticize them, your criticism is tantamount to blasphemy, therefore you must be prosecuted, right? Or you must be accused of anything that borders on the realm of the seditious. Now, ICC and its other, you will agree with me, Professor Clarke, that we are caught in a spell of the liberal consensus. The liberal consensus, of course, having been inaugurated, right? Even before Francis Fukuyama's The End of History, it still continues as a justificatory tool, right? To lubricate the settler colonial logics, right? And of course, which I will say that it's phallogocentric, as Jacques Derrida has said, right? It's phallogocentric in a sense that it does this very idea of having this paternal father who cannot be criticized, and should you criticize him, you will be in trouble. So now, in this liberal consensus, we should not forget the spell that killed the Pan-African pushback. And that spell is a Tina mode. There's no alternative. Therefore, we all have to believe in the institutions, the logics of the markets, and so forth. We should not, I think we should disabuse ourselves. And I want to direct this to Dr. Asaala, that we must abolish ICC. We must abolish the modern colonial world as it is. Like, we need a total reconfiguration, because we cannot push back only at the level of rhetoric and neglect the infrastructures that are still at play. But firstly, let's expose this liberal consensus for what it is. And the liberal consensus, the way it operates, it has the rhetoric and reality. The rhetoric will say, we are all equal before the law, the sovereignty of states. And as we know, that there's no such a thing as sovereignty insofar as the African continent is concerned, because we have to make a clear distinction between the African state and the state in Africa, right? What we are having in this settler colonial encounter and its virology, we are having the state in Africa. So how do we mobilize affective justice, and how do we make sure that we infuse the Pan-African pushback with it? And I think, Professor Clarke, you must be audacious enough to abolish the conceptual frame that you have done of the victim, perpetrator, and the freedom fighter, right? That think about this at the meta political level, since you are concerned with the issue of depoliticization that is at play, and which is insidious and very systematic and systemic in its operation. I think you should abolish this formulation and think seriously from the very idea of the global idea of race, how race is constructed. But I will stop now and then because we can finish tomorrow. Professor Moradi, thank you so much for this.
Thank you so much, Tendayi. We'll start with you now to respond, and we'll come back to the quick Q&A session. Please.
Okay. Thank you to my readers. Thank you, Evelyne, Tendayi, and Travis, and Hannibal. I could talk for the next, you said until tomorrow. Well, yes, we could really go into a marathon with all of these comments and competing and distinctly different comments. But let me start in order of the presentation. I'll start with Evelyne's. So Evelyne and I disagree on the nature of her critique. She ended by saying that the burden is not for the ICC to establish its claim, but it's for, ultimately, I think she said, a society. It's for us to determine what's pragmatic in the context of violence, something like that, but really displacing the burden and really pushing us to ask that we think about the effectiveness of using emotional regimes rather than what international criminal law is actually about. What is it meant to do? And in effect, what she is insisting that I do is to use black letter law in order to make sense of itself. In many ways, she's somewhat rejected the argument and presupposed a lack of complexity in my argument, which I refuse. I don't think that there's a lack of complexity, in fact, including in the Kenyan case that I use in this book toward the middle of the book, that in fact, it is precisely the kind of theoretical apparatus that I'm offering that allows us to think about the nature of such complexity, that political speeches are used precisely for the purpose of its afterlife, what it does, what is its effect. It's not so much, for me, and as far as the argument that I make, it's not so much that it is true that what Kenyatta and political actors through their speechwriters articulate is fundamentally about truth, but it's about its effects. What does it do? What does it mobilize? What emotional regimes does it allow people to hold on to and clarify? What histories, what feelings within the body and outside of the body does it promote? And so it's not about the empirical truth, it's about the effects of those articulations. And that's why the book is really about the work of these narratives and the ways that they encapsulate other narratives and how this enables international justice to take shape. So I think the challenge and the difference is by way of framing, that if we're going to ask, is the International Criminal Court effective, or is it the only mechanism by which we can address violence on the African continent and beyond, whether it's in the beyond being Ukraine and elsewhere, my answer is no. I think Evelyne's answer is yes, that this is a mechanism, this is what we have, albeit imperfect. And I think in fairness to her, she's saying that it's imperfect, but it is the tool that we have to address accountability. And I'm not in the book or at this moment suggesting that we bracket law, that we bracket international law, that there's no use or no value, period. And I'm going to get to Tendayi's point in a moment. But I think that there are strategic moments in which law can be deployed for particular purposes. that in many ways it can establish norms. There are ways that its construction can propel particular effects. But the point is really, and this is a point that I make clearly in the book, that the nature of crimes that we're seeing that are under the investigation of the Office of the Prosecutor, the OTP in the ICC, are political crimes that involve political solutions, that the kind of legal solutions that are brought to bear on Africa's violence will not solve the deep-rooted challenges ahead. And it's not to say that the ICC is the only mechanism and the only tool that we have to address the nature of structural inequality on the continent. But we have to be realistic about what the International Court can do. And if its role is simply if it plays simply an expressive role, then let's talk about the expressive domain and recognize it for that. But ultimately, and this in many ways follows an argument that Mahmoud Mamdani has long made, that these are political problems, that these are age-old structural problems that require political and structural solutions, and that law can be deployed strategically, but certainly not as the answer, because part of the problem is the law itself. And this is where I think in Hannibal's comments, it's quite useful to think about the ways that that part of the problem is the structure of law itself. In the book, I talk about temporal jurisdiction and the inability to deploy particular kinds of criminal laws in order to address questions of accountability, when accountability goes long beyond the initial moment of a crime, whether it's in Kenya or of a form of violence, whether it's in Kenya or elsewhere. That in so many cases, we're talking about colonial inscriptions, land dispossession, economic dominance, forms of theft that haven't been rectified, forms of violence that are actually ongoing and so mundane that we take them as a given, whether it has to do with the nature of race and racism in these contexts, or whether it has to do with other formulations where we don't even recognize theory building on the African continent. We don't recognize proverbs as having the potential to build theory. Instead, we look elsewhere for those conceptualizations. And so, and this goes back to the age-old refrain about the master's tools. Can we use the very laws that have established a title-based system and a property forms of territoriality to address the very forms of violence that are unfolding underneath it? And part of the problem, and this is where Hannibal's comments, I think, are quite useful, especially the way that he ends by asking me to consider the future of the court and to what extent, how do we make sense of the paradoxes that are at play, that many of those interviewed in the study, of course, point to the longue durée of violence, or even the short-term durée, thinking of the war in Afghanistan and Iraq, and the extent to which, on one hand, the UK is actively engaged in the war crimes against Russia and Ukraine, yet on the other hand, we have not yet dealt with their complicity in other contexts, including in African contexts, including in the history of colonial disenfranchisement that continues, yet questions of culpability and criminality can't be deployed in those contexts because they're outside of the temporal subject matter, the temporal jurisdiction of these courts. So it raises questions about the potential for liberal legality to deal with what's at the core, the underneath of things in terms of violence. Hannibal also asked questions about affect and justice. And I think part of what he might have been suggesting in a subtle way is that he didn't quite think that if we take the definition of affect to its limits, that the book is far from effective, that the that in fact it does the contrary, I think, is his critique, that it appeals to the sovereign equality of states by thinking, by using the language of law to think about the deployment of an African court and the ways that Pan-Africanist leaders and African leaders are deploying that language to produce new possibilities through legality. But in fact, I would disagree with that formulation and say that part of what I intended to do with the book through Affective Justice is introduce a framework around which these concepts of legal technocratic practices, embodied practices, and emotional regimes could be actually seen as component parts whose interplay is central to the ways that affective justice works. We can't see the inner world of the individual. And of course, the study didn't involve lab work where I used nodules on the brain to examine responses. There's an impossibility there with this kind of social science work. But what is possible is to think about the interplay between all of these things and how that interplay can offer us a formulation for thinking about the way that these truths become normalized and the way that they become perpetuated in these various contexts. So Hannibal, you can certainly come back and defend this point later, but I don't think that there's an absence of affect, and in fact part of the point is that the form of normalization and regimentation that makes viable and creates new norms and creates certain practices, or makes people feel happy or sad or upset or indignant, that these things are not simply about individual responses. They're shaped by a whole set of things that are a priori and that have afterlives. And so the formulation is an attempt to think about that. So very quickly then to respond to Tendayi's comments. Of course, we have an agreement here. Tendayi's engagement and critique of the book, probably what he's saying is that I could do more. I think the point of departure is quite similar, but the call is to trouble more questions, including the criminal, including the international, which I totally agree with, the construction of the international, and a call to re-anchor Pan-Africanism in a different formulation. And I think it is truly an important point, that the nature of the Pan-African, the kind of Pan-Africanism that we see at the UN, at the African Union, is not necessarily a decolonial Pan-Africanism. It isn't necessarily a revolutionary Pan-Africanism. It is a form of pushback in the name of Pan-Africanism that produces particular things, that enables and establishes new relationships, that even produces what I call, using Sarah Ahmed's work, non-performatives, where you have legal non-performatives, where the Speech Act, the ability to say and to speak to a given issue, might not at all be transformative, right? So when I say, that the African court should thrive and resolve all violence, and if I am a leader of a country in an African context and I'm making that declaration, yet I'm doing nothing to make that happen, that's a legal and political non-performative, in the sense that the Speech Act fails. If we see the Speech Act as failing, we have a problem. Because the Speech Act actually doesn't fail. The Speech Act does what it intends. It is simply a statement of fact that we need this emancipatory potential, but there are no actions that enable us to get there. And the kind of actions that will enable this kind of transformative change, and it's a non-performative. And I think that in part, this is what Evelyne was getting to in her critique of my use of narrative, that these performatives, the nature of performativity and political speeches should be questioned. And yes, they should be questioned, but the book is interested in the afterlives of these speech acts. What do they do? what do they mobilize? For what purposes? To what end? It's not about their truth form. It's about the afterlife of that utterance and its potentiality, whether it's an affective potentiality or whether it's a potentiality that is effective that produces particular ends, like the writing of a new treaty or the signing of and drafting of a different document, or the passing of a treaty that then can be enforced. And in the case of the ICC, of course, enforced means 60 countries ratifying that treaty. And so these things are interrelated, and really that's part of and central to the framework that affective justice offers. So I'll stop there with those defenses of the book, and hopefully my comments further clarify some of the points that were raised. And I'm happy to accept a pushback or take additional questions. Thanks.
Thank you. We have 2 questions, and I'll ask Evelyne, Hannibal, and Tendayi, if you want to come back and raise more questions, feel free to do so. So we start with Gail, if you hear me.
Yes, thank you so much, Professor Clarke, for your book. I find it very, very interesting to focus on this idea of the affective aspect of justice. And there's an article I read, it's 25 years ago, Ward Goodenough. So I have no idea if you referred to his or many other ideas of effective justice, territoriality, but he made an argument that we human beings, it's part of our nature to feel this feeling of moral outrage for the out group, for people who are not in our group. They're the ones we think have done outrageous wrongs. But if someone in our own group does the same thing, we react with more sympathy, perhaps because we understand the contextuality. I know why my kid did this, and I think I can talk to my kids so they won't do it again. I'm not going to turn them over to the police. And the same with my nation or my in-group within my nation. You know, we may have made errors, but we're on the right side and we can work with each other. So this whole question of compassion and how people can feel it, but only to their own group. Now, I always thought Goodenough, I wasn't sure if he was right because he made it sound like it's part of our animal nature. And I didn't know if it was part that or part of our nurture. But there are other philosophers who said emotions, many of our emotions are always a combination of a feeling and a thought. So Martha Nussbaum, Nancy Snow said, we feel compassion towards people if they meet our criteria for people we let ourselves feel compassionate about. And if they don't meet our criteria, we decide not to feel compassion. And the whole transformative justice movement, if I understand, is trying to say, let's feel that compassion. Not that we dismiss people or give them a slap on the wrist or protect them from any kind of justice, but let's feel compassion for perpetrators, get into their skin, understand them, and then devise a way for the entire community to heal instead of being involved in retributive justice. So I think of that as the transformative justice approach, and it's different from universal justice. So the person who wants universal justice is really challenging this double standard of our emotions. But what does it mean? Does it mean we won't feel any emotion for anyone? We'll just use reason. And we do it? Or does it mean we'll feel emotion for everyone? And the arguments for universal justice have gone back to ancient China with Mozi, universal love, and the tale of the eloquent peasant in ancient Egypt for the long time. Justice must be straight, justice must be equal. But what is that equality? What is that middle position where we can judge all parties equally? Because I agree, the ICC is flawed. Your missionary friend, I feel like I would have said, the US is wrong and the other countries are wrong, and not just protect one and tell the others wrong. But what would be a helpful way to train, can we train our emotions so that we have compassion and we can have a transformative justice which will make our world a better place?
Thank you. For those interested, I think I left the link to that article by Good Enough, which you can access online. Reginald, do you hear my voice? Do you hear me, Reginald?
Can you hear me now?
Yes, yes, please go ahead.
Yeah, thank you, Professor, for a wonderful book. I am not trained in law, but I do hobnob with lawyers quite a bit. And one of the things that I take away is the phrase liberal legality, if I got it well. But what I really wanted to ask you, you are dealing with a very important topic, how the powerful states are using the law to subjugate, in a sense, to subjugate countries that are not as wealthy, are not as militarily equipped. But I am just wondering, would you, what would you make of this particular diagnosis, that in fact, what you are dealing with is really the tip of the iceberg, that the more fundamental problem is the current global system, the current state system, the current United Nations system, where those who shout loudest about democracy and equality enjoy veto power, enjoy immunity despite committing crimes left, right, and center, and then preach at the rest on how they should submit themselves to the ICC. Would the more basic problem be the dismantling of the current global system and the establishment of a more equal one? Because the law does not function in a vacuum, but is actually a reflection of more concrete facts on the ground. Thank you very much.
Weston, you hear me?
Yes, I do. Thank you so much. Quite a mouthful to reflect upon. Congratulations to Professor Kamari and the discussants for the insights. Just a couple of things to raise. First, I wish to respond to Evelyne. When Evelyne talks about the ICC vitiating democracy in Africa, I don't really understand what that means. Because I look at it as now holding the ICC responsible for democratic backsliding in Africa. And when those who have been indicted by the ICC dig in the way they did in Kenya and elsewhere on the continent, transfer individual responsibility to communal culpability, and invoke Pan-Africanism quite cynically, threaten to destabilize those countries further. I don't think it's persuasive to hold the ICC responsible for that. We have got cynical politicians who are taking advantage of the social, political, and economic challenges in their backyards to really mess up with every other person. And therefore, the question that would arise is, before the ICC, for instance, intervened in Kenya, how was the state of democracy? And after the cases collapsed against Uhuru Kenyatta and William Ruto, how is the state of democracy like? In fact, the two have fallen out for the simple reason that they came together to fight back against the ICC. And since the ICC is out of the question, as the country gears towards the elections next August, they are falling out and they're bitter rivals. So that's how African rulers cynically manipulate the ICC for their self-serving ends. And therefore, in as much as the court is flawed, and we agree as far as that is concerned, it's also important that we take cognizance of the fact that we've got quite a number of cynical rulers on the continent who once, they are being told to account, held to account, they will tap into Pan-Africanism. They will invoke a whole host of concepts basically to save their skin. Evelyne, I would also have wished you fleshed out the Truth, Justice, and Reconciliation Commission. Because when you talk about alternative mechanisms in resolving conflict on the continent, yes, we agree that we cannot rely on the ICC. It can only do so much because it goes for the masterminds. What about these other low-tier perpetrators? What becomes of them? So Truth, Justice, and Reconciliation Commission in Kenya, which was supposed to help the country also resolve its intractable problems, ran into choppy waters. I would invite some of you to read, thoughts by Professor Ronnie Sly, University of Seattle, who was one of the commissioners. And he's documented the skullduggery that characterized the work of the commission, how some commissioners were taking instructions from the State House in Nairobi and sabotaging this work. And as we speak, since the report was handed over to Uhuru Kenyatta in 2013, it has never been made public. And anybody who's interested in what transpired, what is contained in the report, you have to go to the archives of the University of Seattle. So the alternative mechanisms we're talking about, I don't think there's political will on the continent to resolve these conflicts locally. So the mantra about African solutions, African problems, remains simply that, hollow for the political elite to basically advance their economic and political ends. And therefore, as scholars, we have to be very careful about that. Going to Tendayi, I admire your thoughts and the insights you're bringing forth. But I also wish to invite you to reflect that just as Kamari spoke about, the invocation of Pan-Africanism, don't you think it's also, she puts it, this non-performative, sense, in the sense that this is Pan-Africanism that is exclusivist. Why is it that we don't invoke Pan-Africanism when it comes to rebel leaders in the DRC, Lord's Resistance Army, in Central African Republic? When the ICC comes knocking for these guys, we don't raise any noise. Are they not Africans? So Pan-Africanism only applies to African leaders. What about the victims of these crimes? They're not Africans? So this exclusivist Pan-Africanism concept, I think we have to be careful not to advance it because it's elitist and it is cynical and it is serving the ends of rogue political operatives who are reluctant to operate within the realm of the rule of law, much as the international criminal justice is flawed. But what is the alternative? What is the alternative? Should the victims of mass atrocities on the continent be left to their own devices? What about the ICC? When it's ratified, doesn't it become part of the legal regime of the countries that have ratified it? Does it remain an external court? Which reminds me of the ANC government in South Africa, when they went to court. When they tried to, lead a mass walkout from the Rome Statute. And what did the court tell them? The ICC is not an external court. It's part of the South African legal regime, and that's what it means. So it's not an external court. It's part of the Kenya legal regime, part of the South African legal regime, and many other countries that have ratified it. And to end, where do we put people like Yoweri Museveni, who actually instrumentalizes the ICC? He invites the ICC, to Uganda, gives them support as they go after Lord's Resistance Army, and then he somersaults and starts criticizing the ICC. Where do you place those those kind of leaders of the continent. I think there are so many issues we can raise. Thank you so much, Professor.
Thank you, Weston. We have two more questions. Dr. Shingi?
Thank you so much. I can't turn on my camera, but I think I hope that it's okay for me to just ask my question this way. I think I want to echo or piggyback on the last contributor, because basically my question has to do with the idea of Pan-Africanism. I have read the book and I engaged with it a lot for my PhD work. And I think I would want to affirm Professor Kamari Clarke that I agree that your work does not lack in complexity and nuance. I think that throughout the book, I was both encouraged and sometimes confused by the level of complexity that went into a lot of the analysis. So in that regard, I definitely affirm you that I think that your analysis has a lot of depth and nuance and complexity. My question has to do with Pan-Africanism and the idea that Pan-Africanism, as it's deployed in a lot of literature and definitely as it's deployed by the African Union, seems to be static. It's almost as if Pan-Africanism can only be a reflection of the fight against colonialism and neocolonialism. And so just like Weston has said, Pan-Africanism has become a tool that's deployed almost as a monopoly. It expresses the monopolized voices of politicians, states as they embody the voices or the desires of politicians, of political elites, of military leaders. And I would wonder or would want to ask what you think a Pan-Africanist pushback would look like when it comes to the question of international criminal justice. If Pan-Africanism was reflective of people's voices, of ordinary Africans, the voices of CSO, people who lead CSOs, human rights activists, people who come from marginalized groups, what would it look like if we conceptualized or constructed Pan-Africanism reflecting the voices of people who were born in 1994, 2002, under the current post-colonial African state leadership? What would that look like? And would you consider, or rather, would you consider what Pan-Africanism would look like or sound like, or would ask the ICC or regimes of international criminal justice to respond to if it considered technically our voices and not the voices of our leaders? Yeah.
Thank you so much, Shangi. We take the last question from Zenon.
Yes. Do you hear me?
Yes, please go ahead.
Okay. Yeah. Thank you very much. I think I do not have a lot to say, but what I want to emphasize or to reinforce is on Sithole's comment. We have to go deeper and then interrogate the concept of justice. And when it comes to Africa, I think it becomes like a drama or another.
We lost you, Zenon.
Or emerge from, hello?
Yeah, please go ahead, please.
Yes, comes or emerge from the Iran-North American decision. Because look, when it comes to army, they have NATO. When it comes to justice, they have the ICC. And when it comes to the region, they use or they have the Pope. So when it comes to the first-ranked universities are from the, for instance, Harvard or Cambridge or Oxford. And when it comes to knowledge production, only thinkers from the North America have the right to produce valid knowledge. So then the ICC need to be totally abolished. I agree with Prof. Sithole on this point. And I disagree with Evelyne that ICC can help African nations to maintain effective justice. Hence, ICC itself is a tool which is politicized. And I think it's going to be difficult, and the ICC will never be an effective justice if I come to the topic itself of the book. For me, the ICC, it will never be an effective for the colonized Black subjects. Hence, they are them who are more targeted by than others, because my point is ICC is a tool politicized that has been structured by the North America to dominate the world of justice. Thank you.
Thank you so much. I have, if it is fine for all of you, Kamari, extended, we can go on for another 10 minutes so you can respond to these questions, and people have issues, so they want to raise. There is one question from Maxine Robin to Evelyne. Maxine is asking that you have mentioned African violence. Okay, what do you mean by African violence, and to explain why it is distinct? Why do you think it is distinct from a more general definition of violence? So first we start with Kamari and then come back to you, Evelyne, to engage with that question briefly.
Okay, all right, thank you for the questions. So let me start then with Gail Presby's point, which is really, she's asking what is a helpful way to train our emotions, to have compassion, to make our world a better place. I think that's ultimately by recognizing some of the scholarship that has predated us, Goodenough's work and others' work, especially in anthropology, but beyond, you know, where do we go from here? How do we, if we recognize that our responses are culturally shaped, where do we go from here? And to answer that question, I would direct Gail to chapters 3 and 4 of the book, actually, because part of what I'm interested in the book is the nature of contemporary biomediation. So that is the use of these new mediated forms, so Twitter, hashtags, the kind of the use of imagery, the potential to use a phrase and for that phrase to go viral with some kind of video footage, and through that create the most effective forms of dialogue, right? That like never before, we're seeing the kind of time-space compression that's leading to a circulation that usurps formal media. And these modalities have implications for what people do, how they do it, how the law is deployed. The technologies that are used are critically important in thinking about the nature of justice and the possibility of international justice today. And so a central part, we haven't talked a lot about these various modes, but an important part of the book is really to think about how these modalities are mobilized through speeches and through narrative and through images to do this work. And so to Gail's question, what I would say is that certainly we need a new framework for justice. And not only do we need a new framework, but through these frameworks, we need to see the exclusions, those things that are not part of the frame, that we can't see because it's not the way that we've built out our conception of justice. And part of it is to reckon with that which is invisible to us. Maybe it's invisible because it's so mundane in the everyday, but we need frameworks that will allow us to continue to interrogate those things that are not visible and legible to our definitions. And certainly that's the case if we think culturally, if we think about practices and the ways that justice gets conceived. To the next question is from Reginald, and this is a question about liberal legality, and he spoke of the way that powerful states are using the law to subjugate others. And the idea that the law doesn't come from a vacuum. And so I absolutely agree that even the book, if you read the epilogue of the book, you'll see, in fact, even if you start the book with the epilogue, it really does foreground the stakes that are central to the thesis of the book, which is that justice doesn't mean the absence of injustice. Justice means that we need to work together to think about modalities and measures and practices where we can agree on that which we can accept. So justice is not the absence of injustice, but it has to do with the practices of making viable and possible equality for everyone, and that we need to be part of that negotiated process. The ICC isn't the place for that. The ICC may have a different role at a given point in time. It isn't the central place for the procurement of justice. And I think that we've already established much of the critique around international criminal justice really does raise some of the limits to the law in addressing the nature of violence in the first place. And so absolutely agree with Reginald on this point about the law not functioning in a vacuum, and that in fact, there needs to be a greater site of negotiating and practice through which we, on multiple micro levels, engage in what justice means in different contexts. So the next question, this is Western asked about truth, justice, and reconciliation mechanisms, and I wasn't quite sure where. I mean, just Western was interested in Evelyne's critique of my book, and ultimately, I think wanted me to comment on the extent to which international justice can be used to produce the terms for justice in the first place. And if not, then what are the other modalities? And he, of course, pointed to Truth, Justice, and the Reconciliation Commission in Kenya, which had its challenges. And yes, I've read the report by Ron Sly on this point. But I return to the need for a new framework for justice, whether it be called international justice or whether we think about new domains and measures through which we deal with rectification of inequality. And the popular transitional justice mechanisms aren't necessarily the go-to places either. And so this is a larger conversation about what is available to us. How do we rethink and think differently about the world in which we live, where we can address structural inequality in a way that also thinks through the nature of violence. So the kind of political economies that are both historical and that continue in the present. And then Dr. Shingi's question, thank you for the engagement with my book and pushing me on this idea of Pan-Africanism. And I think if there's a weakness in my argument, it is in relation to my engagement with Pan-Africanism. And I remember once when we were at the AU in Addis Ababa, and I remember doing an interview with one of the someone in one of the units, one of the offices at the AU, and I asked him, as I asked many during interviews, well, what is your definition of Pan-Africanism? And of course, this was at a time when the AU, from the OAU to the AU turned 50, there was a celebration of the AU and of Pan-Africanism. So Pan-Africanism, the language of it was at large during the time of this work. But what was clear was that Pan-Africanism wasn't necessarily seen as liberatory. And I remember when I asked this one person what it was, he jokingly said it's his ability as a Black man to buy shoes in Italy, Brazil, and in Nigeria all at once, perhaps on Amazon or, through some modality, but it was about economic empowerment. It was about the Me Too in the sense of laying claim to a world of economic access, laying claim, being part of, having membership in a world of economic power, of political power, being on the world scene and seeing African states present and voting in a judicial process or in a UN process. And so Pan-Africanism was about membership and engagement in a pre-existing international system. What many of you in your comments have pushed me to and critiqued me for has been the limitations of this kind of Pan-Africanism. And it's not so much that I'm putting forward this as Pan-Africanism, it's that I'm looking at the way that Pan-Africanist discourses are being deployed for the purposes of particular ends. So I'm not taking a side that this is what Pan-Africanism is, but this is its deployment. So the pushback is in the name of Pan-Africanism. And that Pan-Africanism may not be the liberatory Pan-Africanism that my colleague earlier was ascribing to, or that I would ascribe to, but it is in the name of Pan-Africanism. And that's really what the book is about. The analytic and the theoretical framework is an attempt to show how these narratives are deployed under particular regimes, invoking freedom fighters and colonial leaders and post-independence leaders, I should say. And so it's in the name of that these mobilizations are made. In the same way that the Nuremberg Tribunal and the International Court do their work in the name of the, quote, victim. So the victim becomes the figure that mobilizes the moral economy of its work. And I'm very interested in that. And I think more and not less, we need to think about the ways that we mobilize narratives and that we mobilize imagery and that we call on the past in particular ways. And it becomes deployed in the name of that thing that actually isn't what's going to lead us to the kind of liberatory ends that can produce a world that we want to imagine that is free of the things that we all deserve to have, including freedom, right? The life, liberty, all of those things, food. So Dr. Xing, I would love to follow up with you on that point. I think it's an important one, and there are ways that I could have made that more explicit in the ways that I map out the second half of the book. But so thanks for that question. And then the very last, and I'll be done in 30 seconds. This was, I think, Zina's question, asking us to interrogate the concept of justice. Yes, in fact, I couldn't agree more. The point about the ICC needs to be abolished. The ICC is a tool which is politicized. I think there's so many tools in our world that are at once liberatory in the sense that they're enacted with blind spots to do particular things, and they do the opposite. And it's not just the ICC with its problems, it's legality in general and the purposes it serves. Yet at every moment, each of us, if we were to ask if we had the misfortune of some kind of crime against us, our loved ones, etc., what recourse would be available to us? Would we want the existence of a court, of an international court? And if so, what would it look like? And I think that it's that thought exercise that's critical for the work ahead, for the future that Hannibal spoke of. What should that mechanism look like? And if the ICC isn't getting us there with the multi-millions of dollars that are part of its cachet, then how can we redeploy those multi-million dollars in order to create a modality that can actually get us there, that can deal with some of the root causes of violence in the first place? So I'll end on that note. Thank you to everyone, especially the commentators, for your comments. Evelyne, thank you for your insights. I'll continue to think about some of those points, certainly. And although we don't agree, I think it's important to understand where we are and what the nature of that intervention is and why. So thank you all.
Thank you, Kamari. Evelyne, would you like to just respond very briefly before we end?
Yes, very briefly on the last question, why I think African violence are different or complex from other violence. A lot of the violence we see on the continent, actually, we are in a setting where you see an entire community rising up against the government or against another government. And the complexity in this is that, how do you then question an action by an entire community rising up against another because of reasons of subjugation, marginalization, oppression, and all that. And the challenge is therefore holding all the members of this community accountable, really. And you find the inadequacies of international criminal justice system being evident in this. For example, think of the violence in Rwanda, think of the violence even in Kenya, where you have an entire community or an entire mass population rising up against another because the only avenue they have to change leadership or government has been whitewashed or has been compromised, and therefore they cannot have an effective democratic transition to a set of government or leadership that can address their grievances. And so what they do is to rise up in arms and engage with whoever they think is their oppressor, whether it is government or it is the other community. And so it creates a complexity or inefficiency or insufficiency with international criminal justice, in the sense that while international criminal justice perceives the individuals who are responsible to be criminals or potential criminals, to these communities, they are heroes because they are trying to help them achieve certain self-determination. And that is the complex nature of this kind of thing. So we are asking ourselves, should international criminal justice go for all these people at the international level and national level? Or, how do we then address this kind of complex scenario? That was my approach.
Thank you so much. I don't really know if Hannibal and Tendayi wanted to say something before we end.
I just did want to say briefly, I didn't mean to be to sound as critical of the affective justice thesis as perhaps I did. My comments, I intended them more along the lines of what Gail was saying, Professor Presby. And I also didn't mean to be as critical of international criminal law as I maybe sounded, because I think there is value in the ICC prosecution of, for example, al-Bashir. I don't think that Ocampo or Fatou Bensouda were subjugating Sudan by indicting al-Bashir. I don't think they would be subjugating the United States to indict United States leaders. So that's sort of a topic for another day, but just to clarify two aspects of my comments. Thank you.
Tendayi?
Thanks, Prof. Moradi. I just need to clarify some matters on Pan-Africanism, because in my response, I was not in affinity or apologetic to the African leaders. I still insist that we have a ICC and its others. Tout. That's a reality that we are in. And I must restate that Pan-Africanism, as used, misused, and abused by the AU, it is the bastardization and the mutilation of the concept as it is, right? So Pan-Africanism is not reducible to the neo-colonial and bastardized formation that was done by the African Union. Pan-Africanism, in its original sense, of course, with radical mutations through various concepts, is continuing. And Dr. Shingi, as you know, that mentioning the issue of the post-colonial and the post-1994, those historical events or markers, they were nothing but cosmetic affairs that did not change anything. Hence, in my response, and I will elaborate that we are still in the longue durée of the long settler colonial regime, which is chokeholding us not to imagine other possibilities. So Pan-Africanism still exists as it is. The one of the AU is not Pan-Africanism. We can all agree with that. It was just an elite affair. And as you know, that African leaders and also the Euro-North American imperial formation, they are in cahoots against the people of this continent. Hence, I highlighted a distinction between the state in Africa. We don't have African states. We have states in Africa, right? It's a Westphalian imposition that came as a result of the Berlin Conference. We are yet to have African states. We've never had, because these leaders, they are put through this illegal game called elections by the very same colonial masters, not by the people that we declare as victims. Just briefly to Western, I think we have to be careful against this censoring alarm called "we must be careful." We must be careful of that thing that says we must be careful. It's a very, very, very troublesome phrase that is used to censor. We must be careful. Oh, there are complexities, there are nuances. No, those are just gimmicks that are there not to make us to interrogate. What I'm saying in relation to Pan-Africanism, you will agree with me that the Pan-Africanism that I am calling for, it is the one that is coming from the victim's perspective, not the African leaders, not the ICC. Hence, I want us to dwell to ICC and its others, right? The ICC will not have legitimacy if it does not confront people who did the a priori crimes, right? The settler colonial question. Number two, the recent conquest that we are seeing, the invasion of Iraq, all of these things that are happening, right? So, but we're gonna see the ICC being active now, or people in Ukraine, and we see that we are being told today that, oh, it's not like those people in Africa, right? Let's think about these things of we must be careful. In fact, we must not be careful. We must be careless enough to ask difficult questions. We should not censor ourselves. We have nothing to apologize for. Professor Clarke, I will humbly want to urge you that in your next coming project, because this is a very, very rich book, right? And as I've asked you outside this platform, how did you do it? I don't know. It was a difficult project, the way like you have said it. And before I have the brief remarks on you, I fully agree with Mr. Ndaisenga that let's make a distinction between justice and just us. Let's start there. We have justice, right, and just us. So it is justice insofar as it concerns the well-being of the Euro-North American centric. Professor Clarke, the issue of Pan-Africanism, I would want you to steer it, take it away back from the AU, give it back to the victims. Hence, I said to you, abolish that typology that you made between the victim, perpetrator, and a freedom fighter. Abolish it. Take Africanism back, give it back to where it belongs. And what you must do, you must make it a liberatory project, not the emancipatory project, because emancipation, it is the freedom that comes from the Euro-North American centric empire who says, oh, Africans, now you are free. We are yet to free ourselves. So take it back. I will help you with that. Thank you.
Thank you. Thank you so much, Tendayi.
Okay. I have to come in here.
Very briefly, It is possible that Zoom will cut us out. If you could
Okay.
just please, yeah.
Okay, great. So Tendayi, thank you for that. But I have to say that those categories are not my categories. Those categories live in the world. The figure of the victim, the language of the victim is highly problematic. The language of the perpetrator, an individualized perpetrator with individual responsibility, is highly problematic, as is the freedom fighter, as is so many other categories. The question is, what work do they do? How do they propel and how do they work within particular emotional regimes? The Liberatory Project is, for me, it's for all of us. And so thank you for the call for a liberatory project that allows us to think about what justice is and can be. And it's certainly my commitment, but I think it's all of our commitments. And the task is enormous. We're talking about micro, meso, meta, a whole set of formations that are complex and contradictory, that are not portable. We can't take it from Afghanistan and move it to Nigeria, or take it from Nigeria and move it to Toronto. And they're constantly negotiated, because even in those spaces, the tremendous amount of stakes and complexity and differences loom large. And this is the work ahead, to both envision what justice looks like and to think about what tools are available to us to get there. But I do, and finally, I have to say, yes, of course, I love what you're saying about Pan-Africanism. I think it's a great point. And, I absolutely agree with that point about Pan-Africanism, and give it back. I like that. And when I work on this next, the book that I'm working on now, I will smile as I think about you, as I think through many of those issues, and maybe we can be in touch in the future. So thank you.
Thank you so much. I just want to thank all of you. Thank you, Professor Clarke. Thank you, Hannibal, Tendayi, Evelyne. Thank you, everyone, for being here. And we are going to continue this conversation. And Reginald left, but he is the editor of a book called Africa Beyond, Neoliberal Democracy. I think Gail Presby will be with us in September. I hope. I don't know. But the conversation continues. And I had a lot to say, but I'm sorry. I don't have time for it. I'm just scared that that will be cut out from Zoom. Thank you so much, and we'll be in touch. And have a wonderful time wherever you are. Thank you so much for being with us. Thank you. Bye.
Thank you, everyone. Bye-bye now.
Thank you. Bye-bye.